Imagine you walk into a courthouse knowing that the next few weeks will determine whether you get your life back or lose everything. For some plaintiffs, that courtroom gamble pays off in ways that seem almost impossible. $101 million, $27.5 million. Numbers so staggering that they barely feel real. But they are real, and the stories behind them reveal something crucial about how our legal system actually works, and what separates a losing case from a life-changing victory. This is the verdict room, and today we're dissecting the personal injury lawsuits and settlements that won millions. What the evidence showed, what the arguments were, and most importantly, why the system decided these plaintiffs deserved that kind of money. Let's start with something fundamental. Most people think personal injury lawsuits are about punishing the defendant. They're not, at least not entirely. A personal injury case, also called a civil tort, is about making the plaintiff whole. If someone's negligence or wrongdoing caused you harm, the law says you're entitled to be compensated for that harm. Medical bills, lost wages, pain and suffering. But when does compensation become $100 million? That's the question. The answer lies in something called damages. There are actually two types. Compensatory damages are supposed to put you back where you were before the injury. If a surgery cost $50,000, you get $50,000. If you lost wages for 2 years, you get those wages back. That's straightforward math. But then there's something else entirely: punitive damages. Those are designed to punish the defendant and deter others from doing the same thing. And punitive damages, those are where the real money lives. Now let's talk about a verdict that made headlines just months ago. In January 2025, a North Carolina jury awarded a plaintiff $101 million. $101 million. This case made national news. It was reported by the Watauga Democrat and caught the attention of legal observers across the country. But here's what's crucial. The case didn't come out of nowhere. It was built on evidence, on testimony, on a narrative that convinced 12 ordinary citizens that justice required that amount of money. We need to understand what kind of case it was. Was it a medical malpractice case? A product liability case where someone was injured by a defective product? A wrongful death case? The specifics matter enormously because different types of harm command different levels of compensation. A landmark verdict in North Carolina in 2025 tells us something about the current state of personal injury law. Juries are willing to award massive sums, but they're not doing it lightly. The evidence in these mega verdicts is always overwhelming. We're not talking about he said, she said. We're talking about clear documentation of what happened, expert testimony about causation, and a compelling narrative about the impact on the plaintiff's life. When medical malpractice cases reach these levels, for instance, there's usually expert testimony from a physician who can clearly articulate how the defendant doctor departed from the standard of care. Standard of care is a legal concept. It means what a reasonably competent doctor would have done in the same circumstances. If a defendant doctor fell below that standard and that departure caused measurable harm, you've got the foundation for a major verdict. But let's shift gears for a moment, because there's another type of case that generated headlines in 2026, and it reveals something different about how the legal system values justice. In Chicago, a man who was wrongfully convicted of a 2008 murder and spent decades in prison was finally exonerated. When he was released, the city of Chicago settled with him for $27.5 million. This wasn't a jury verdict, it was a settlement. But the number itself tells you something profound about how the legal system now views wrongful convictions. This Chicago case represents a different kind of personal injury. It's not about a car accident or a surgical error. It's about the justice system itself breaking down. A man was convicted of something he didn't do. He lost decades of his life. According to reports from WTTW, this settlement set a new record for wrongful conviction payouts in the city. That's significant. It tells us that juries and the officials who authorize settlements are increasingly recognizing that there's a measurable, enormous cost to being imprisoned for a crime you didn't commit. Now here's where the legal framework gets interesting. When someone is wrongfully convicted and later exonerated, their path to compensation has evolved dramatically in recent years. Some states have statutory damages. The law says if you're exonerated, you get X dollars per year of wrongful incarceration. But many cases, like the Chicago example, are handled through civil lawsuits where the plaintiff sues the city, county, or state for the conduct of prosecutors, police officers, or other officials that led to their conviction. To win a case like that, you have to prove that someone acted with deliberate indifference to your rights, or with gross negligence, or sometimes with intentional misconduct. You have to show that evidence was suppressed, or that police testimony was false, or that the investigation was fundamentally flawed in a way that violated your constitutional rights. The Sixth Amendment guarantees the right to effective assistance of counsel. The Fifth Amendment protects against self-incrimination. The 14th Amendment guarantees due process. When those rights are violated catastrophically and a person spends 30 years in prison, the jury, or in settlement negotiations, the city, has to grapple with what that's worth. But let's return to civil personal injury cases because they operate under different rules. In a typical negligence case, say a car accident, the plaintiff has to prove 4 things. First, the defendant owed a duty of care. A driver owes a duty to operate their vehicle safely. Second, the defendant breached that duty. They ran a red light. Third, the breach caused harm. The accident happened because of that red light. And fourth, the plaintiff suffered damages. Medical bills, lost wages, pain and suffering. If you can prove all 4 of those elements, you win. Now, in most cases, damages are modest. They're whatever the actual harm is. But when we're talking about $100 million verdicts, we're usually looking at cases where the harm was catastrophic, the defendant's conduct was particularly egregious, and the jury decided that punitive damages, money designed to punish and deter, were necessary. Let's think about what jurors actually consider when they're deciding between, say, a $5 million verdict and a $100 million verdict. Jurors are instructed to consider the severity of the plaintiff's injuries. Will the plaintiff ever recover? Are they paralyzed, blind, cognitively damaged? They consider the permanence of the injury. They consider the defendant's culpability. Was this an accident? Or was the defendant reckless? Or was the defendant deliberately indifferent to the plaintiff's safety? They also consider the defendant's wealth. This is crucial. If a corporation made $1 billion in annual revenue, a $10 million verdict might not be much of a deterrent. But if a small business made $5 million, a $10 million verdict could bankrupt them. The law says that punitive damages should be proportional to the defendant's wealth and ability to pay, and they should be high enough to actually deter the conduct. In 2026, we're seeing something interesting in the landscape of personal injury law. Juries are increasingly willing to award large sums, but courts are also increasingly willing to scrutinize those awards on appeal. There's a tension in American law between respecting jury verdicts, a core part of the Seventh Amendment, and ensuring that verdicts aren't so excessive that they violate due process. The Supreme Court has said that punitive damages awards that are more than a single-digit multiple of compensatory damages raise constitutional concerns. If a jury awarded $1 million in compensatory damages but $50 million in punitive damages, an appeals court might reduce that award. But here's what matters. When you see a $100 million verdict stand, when you see a $27.5 million settlement over a wrongful conviction, those numbers have survived legal scrutiny. They've been vetted. They're not arbitrary. They represent a jury's or a settlement authority's judgment that this is what justice costs. Let's talk about the anatomy of a winning argument in these mega cases. The plaintiff's attorneys, sometimes called personal injury attorneys or tort lawyers, have to tell a coherent story. They can't just present facts. They have to create a narrative. Who was harmed? How were they harmed? Who caused that harm? How do we measure what they've lost? In medical malpractice cases, this narrative often includes expert testimony from other doctors who explain, in plain language for a jury, exactly how the defendant doctor messed up. Maybe a surgeon operated while under the influence. Maybe a radiologist missed a tumor on an X-ray. Maybe an anesthesiologist failed to monitor the patient properly. The expert has to explain not just what went wrong, but why it was wrong, how it violated the standard of care. Then comes the damages phase. Attorneys bring in life care planners who estimate how much money the plaintiff will need for medical care, assisted living, home modifications, wheelchairs, medications, everything they'll need for the rest of their life. They bring in vocational experts who testify about the wages the plaintiff lost because they can no longer work. They bring in economists who calculate the present value of future losses. But punitive damages? That's where the arguments get more visceral. Plaintiffs' attorneys explain that the defendant's conduct was so reckless, so deliberate, so indifferent to human safety that it demands punishment. They show a pattern of conduct. Maybe the defendant knew about the danger and did nothing. Maybe the defendant falsified safety tests. Maybe the defendant chose profit over safety. The defense attorneys, of course, argue the opposite. They argue that the plaintiff's injuries weren't caused by the defendant's conduct. They argue that the plaintiff was partially at fault. This is called comparative negligence. They argue that compensatory damages should be modest because the actual loss wasn't that severe. And they argue that punitive damages are excessive and unconstitutional. In many cases that reach mega-verdict territory, the defense arguments just don't resonate with the jury. That's what's happening in 2026. Juries are increasingly skeptical of corporate defendants, particularly when there's evidence of cover-ups, falsified safety records, or deliberate suppression of evidence about dangers. The legal landscape has shifted. What does this mean for justice in 2026? It means that if you're injured because of someone else's negligence or recklessness, and you can prove it clearly, the legal system is increasingly willing to make you whole. It means that corporations can no longer assume that the cost of a lawsuit is just a business expense. If juries believe you deliberately endangered people to save money, they'll punish you in a way that actually hurts. It also means that wrongful convictions carry an explicit, measurable price. When the state wrongfully imprisons someone, when prosecutors suppress evidence, or police officers fabricate testimony, there's now a financial reckoning. A $27.5 million settlement in Chicago sends a message. Your freedom has value, and when the system takes it from you, you deserve to be compensated. But here's the caveat. These mega verdicts are rare. Most personal injury cases settle for much more modest amounts. Most wrongful convictions don't result in $20 million payouts. The cases we're discussing today are the outliers. They're the cases where the evidence was overwhelming, the defendant's conduct was egregious, and the harm was catastrophic. What's your take? Do you think these verdicts are too high, too low? Are juries making the right calls? Are corporations being held accountable? Or are wealthy defendants simply paying their way out of consequences? That's what we want to know. Drop your verdict in the comments. And if you want to see more deep dives into how the legal system actually works, how real cases are won and lost, subscribe to the Verdict Room. Because the truth is, the law is more complicated, more human, and more powerful than you think.